In 2018, Elon Musk tweeted 9 seemingly innocent words that allegedly took Tesla investors by storm. Those 9 words may make Tesla investors a lot of money if the recently started shareholder lawsuit trial wins in court. What are the chances that shareholders win? How much can they win? And how can you join similar shareholder lawsuits in the future? My name is Hoda Mer. I am the founder and CEO of StockCard, and like many of you, I'm a Tesla shareholder. Elon Musk is many things, but being careful about what he says isn't his strong suit. And this has brought him so much popularity and trouble simultaneously. It's hard to forget his tweet influence on the rally and crash of Dogecoin price in 2021, granting him the unofficial Dogefather nickname. For now, that's all good and fun in the cryptocurrency space. However, in the stock market, from January 17, Elon has to fight a case against several Tesla shareholders who claim his reckless 2018 tweet about taking Tesla private at $4.20 per share and the affirmation that he has secured the funding has caused them significant financial damage. If shareholders prove that Elon's tweet has caused market price fluctuations leading to financial losses between August 7th and 17th, 2018, they can win a lot of money, and I mean billions of dollars in financial damages. In this episode, I'll recap the case, investigate either party's chances to win the trial, and most importantly, I go through how we can use the stock market's information such as price, volume, and options data to calculate the damage to shareholders in such cases. In the end, I'll wrap up by using research I've done and share information about how you can get compensated by similar shareholder class action lawsuits. So stay for the entire episode to get all that information that took me several days to gather. This episode is the one you don't want to miss. Before we start, as a reminder, I'm not a lawyer or a financial advisor. This episode is based on my research and it's for education and entertainment only. Talk to a lawyer or a financial advisor if you need help. While many shareholders have already tried to sue Elon Musk over his infamous 2018 funding secured tweet, there is one lucky, or depending on how you're looking at it, an unlucky shareholder who is leading the lawsuit against Elon Musk, the one and only Mr. Glenn Littleton. Glenn is the lead plaintiff in this case who claims he has lost $3.5 million in Tesla investments because of Elon's tweet and subsequent statements. He is represented by New York-based Levi and Korsinski law firm, a reputable and successful law firm specializing in shareholder class action lawsuits. Let's start with this saga's timeline. On the last day of July 2018, Elon met with the senior leadership of Saudi Arabia's public investment fund to discuss taking Tesla private. 2 days later, on August 2nd, Elon Musk took the idea to Tesla's board of directors, who then authorized him to have initial conversations with Tesla's more prominent investors and discuss the possibility and the structure of taking the company private. 5 days after, on August 7th, Elon Musk's infamous tweet publicly announced that he was considering taking the company private at a 20% premium and the funding for it was secured. On the weekend of August 10th to 12th, Musk exchanged messages with the governor of Saudi's Public Investment Fund, PIF, who asked him for financial numbers and getting the people on both sides to meet, which they had apparently agreed to in their July meeting, and Musk never followed through. A series of press releases, tweets, and blog posts by Tesla and Elon provided updates about the process in the days following the tweet, ending with an official decision to dismiss the entire thing on August 24th. Not too long after, by September 29th, the Securities and Exchange Commission, the SEC, charged and then later resolved those charges against Elon Musk, who agreed to settle and pay $40 million in penalties together with Tesla and step down as Tesla's chairman for 3 years. Then came the shareholders. I already introduced you to Glenn Littleton, the lead plaintiff on this active trial. He was among 9 competing motions filed against Elon Musk for a trading frenzy caused by his tweet. In November 2018, the court granted Glenn Littleton a lead plaintiff status. According to the motion filed to the court, Glenn Littleton has had several different longs, shorts, and options investments in Tesla, granting him a well-representation of all sorts of shareholders in the lawsuit. Of course, nothing related to Elon Musk is simple, and this lawsuit isn't an exemption. Even the decision about who should be the lead plaintiff was challenged by at least 2 other shareholders and law firms in 2018, who argued their cases were a better representation of shareholders. For various reasons, Danny David and a fund called Bridgestone Investment argued that they should be the case lead plaintiff. Such objections are quite rare, but because the trial can end with billions of dollars in damages paid to shareholders and the lead plaintiff gets a more significant percentage of any potential settlement, other shareholders try to ask the judge to reconsider the lead plaintiff's grant. Nevertheless, Honorable Judge Chen dismissed the reconsideration motions and kept Glenn and his legal team the lead plaintiff in the case. Back to our timeline. Between 2018 and early 2022, the plaintiff and his lawyers gathered evidence and did what they needed to do to prepare for the hearings to start on January 17, 2023. In mid-April 2022, federal judge Edward Chen, who is hearing the case, ruled that no reasonable jury could find Musk tweets on August 7th accurate or not misleading, which is already a big win for shareholders and makes their case to the jury even stronger. And again, in April 2022, in a court filing, the shareholders requested Musk to stop talking about the case until after the trial. This was in response to Musk's public remarks at TED conference that he was forced to settle with the SEC on the agency's civil case against him back in 2018 because the company was in a financial crunch and the banks wouldn't provide working capital to Tesla if he hadn't settled.
At the time, Tesla was in a precarious financial situation. And I was told by the banks that if I did not agree to settle with the SEC, that the banks would cease providing working capital and Tesla would go bankrupt immediately. So that's like having a gun to your child's head. So I was forced to concede to the SEC unlawfully, those bastards. And now they it makes it look like I lied when I did not in fact lie.
The shareholders argued that Musk could manipulate the jury by talking about the case publicly. As 2023 started a few days before the hearing, Elon Musk and his lawyers tried to delay the hearing by requesting the judge to move the trial to Texas, where Tesla is now headquartered. They argued that Elon Musk's purchase of Twitter in October had poisoned the jury pool in San Francisco Bay Area negatively against Elon. To their defense, in December, Elon decided to have some fun by going to comedian Dave Chappelle's show and getting on the stage. He then got booed by the crowd.
Cheers and boos, I see.
Nevertheless, the court dismissed his request and the hearing started on January 17 as scheduled with the process of seating 9 jurors. Alright, enough TMZ on an investing show, right? So how likely is it that the shareholders win this case and how can Elon defend himself? Because the judge has already ruled that the tweet were inaccurate and misleading, the shareholders now need to prove to the jury that Elon Musk knowingly tried to influence the market, and through his tweets and subsequent statements by the company, they created a market frenzy that was different from the market's usual ups and downs, leading to significant financial losses by shareholders. They are suing Elon and Tesla for violating the SEC law that prohibits anyone from making an untrue statement of a material fact or omitting a material fact in connection with the purchase or sale of any security. In the case of Elon Musk's tweet, they argued that he didn't actually secure the funding required to take Tesla private and knowingly shared an untrue statement of a material fact that impacted Tesla's stock price. They further sue Tesla's board of directors, who, according to the SEC, is responsible for making sure no one, and in this case Elon, can actually commit such fraud by providing misinformation. Let's talk about what shareholders need to do to prove this case. They have to share that Elon, first, didn't have the funding secured. 2, they have to prove he intentionally wanted to move the price. And 3, his tweets and company's statements have moved the price artificially. Can they prove it? First of all, as we discussed in the timeline section, Elon Musk has already settled the case with the SEC on the same subject, and he and the company have paid a combined $40 million in fines, which can be interpreted as the defendant has already pleaded guilty. Additionally, as evidenced by the facts that presented in the shareholders' complaints, there are several reasons to believe by no means Elon had the funding secured, which in simple terms means he lied on Twitter. The evidence includes Tesla's board of directors had concerns about the deal's proposed terms by Saudi Arabia's public investment fund, which was supposed to be the funding source. Apparently, the investment fund had asked Elon to make a factory in the Middle East as a condition for funding the transaction to go private, and the board had concerns about such condition. The shareholders provided several reactions by Tesla's senior leadership team, including the senior director of investor relations and Tesla's director at the office of the CEO, asking frantically about what Elon meant by his funding secure tweet, as no one did not know such matters. Additional details provided by shareholders reference the board of directors press release the day after the infamous tweet, which did not confirm the funding was secured, dragging the stock price by 2.5%. On the chain of evidence to prove that no such funding was secured, the shareholders presented Elon Musk's blog post where he clearly says the offer by Saudi fund is subject to financial and other due diligence and their internal review process to get approved. If I can jump in here as a company CEO who has gone through several funding processes, funding is never secured until the money is in the bank. Of course, as a publicly traded company, he can't wait until the money is in the bank to make an announcement. But when there is still due diligence to be done, there is no assurance that the funding will go through. It's fundraising 101. Beyond providing the fact that he didn't have funding secured, shareholders are also trying to prove that Elon knowingly tweeted to push the price up and caused Tesla's short sellers to lose money. They provided several pieces of evidence, including selling shorts Tesla merchandise, to prove his animosity against short sellers. Shareholders also try to prove Elon and Tesla's statements have caused the stock price to move artificially. For example, on the day of the tweet, trading was halted by Nasdaq in response to a sudden surge in trading volume. Consecutive evidence is provided to suggest Elon assured the employees and Twitter crowd that the deal is near and only awaiting shareholder approvals, resulting in 10% or so jump in the stock price by the end of the day on August 7th. They can also rely on Elon's allegedly second misinformation on August 13th when he posted about working with Silver Lake and Goldman Sachs as financial advisors to take Tesla private, which drove up the stock price by 1.3% and then was further denied by those firms through an article on Bloomberg the next day, driving down the stock price by 2.5%. What a mess. Those are very strong evidence to prove shareholders' case, but how can Musk and his team defend him, and what are their chances? His first defensive strategy was to move the case from California to Texas, where he may get a more favorable public perception and jury. That defense, as we discussed, was already tried and failed as the federal judge rejected his request. The second and critical defense Elon has is to defend his statement by arguing about the language of the tweet. In his 2018 tweet, he started with "am considering," which is logically a reference to something that is not yet proven. Moreover, Musk can argue that he truly believed the funding was secured. In his opening statement on Wednesday, January 18, Musk's lawyer argued that Musk believed that the financing was not an issue and was taking the steps to make a deal happen and eventually face shareholder approval challenges. Lastly, Elon and his lawyers can argue that the stock price movement wasn't due to the funding secured portion of his tweet rather than the general appeal of the possibility of taking the company private. What Musk has going for him is that no one was in his head, so he can use many arguments to prove he just made an innocent mistake. Perhaps that's why Musk has decided to go ahead with the trial and not settle. Almost all shareholder class action lawsuits settle if they don't get dismissed in court, and you rarely see a trial. He either believes he isn't at fault or wants to make a point and fight the case to protect his reputation. He may also believe any publicity is good publicity, and he wants to keep himself and his company in the public eye. In my opinion, shareholders have a really good chance to win, but what really matters is how much they can ask in damages, which takes us to the most exciting part of this episode, and that's how one can use the market's information to prove an unusual market frenzy. The answer comes from the shareholders' trial briefing document. They use the testimony of financial professors, forensic economists, and financial analysts. They also use the trading volume and options implied volatility to prove the stock price's deviations from the norm. Specifically, they use the fluctuation of the implied volatility of Tesla's long-term stock option after the August 7th tweet. Implied volatility measures the anticipated fluctuations of future prices over the length of an option contract. When future prices are more determined, the implied volatility goes down. This had happened after August 7th tweet. Investors assumed the stock price would be settled at $4.20 per share, which was shared by Elon, dragging the implied volatility to 32% from 50%. As the market learned about the deal and became skeptical of it, the implied volatility returned to what it was before the tweet. That's a quite interesting use of implied volatility, I believe. Don't you think so? Lastly, the shareholders identify the financial damage as the out-of-pocket difference between the fair value of all that plaintiff paid and the fair value of what he would have been paid had there been no intervention by Musk and Tesla. I couldn't find the exact amount of damage calculations filed by the shareholders to the court, but several online articles suggest that it be in the tunes of billions. As a side note, for those of you who seek a career in finance, you can become an expert in forensic economics, like Dr. Michael Hartzmark, who is the expert used by shareholders in this trial case. You can be the next expert in such high-profile shareholder lawsuits, and I bet you get compensated quite well. You're most welcome for this career advice. So let's wrap up by discussing how you can participate in this lawsuit and other similar class action lawsuits. To participate in these cases, you must meet two criteria. First, you must have bought or sold the stock or related securities like options and bonds during the class period. And secondly, you need to find a law firm that can represent you as a part of the class action and provide evidence of your transactions during the class period. If your losses aren't in millions of dollars for you to be a lead plaintiff, you can still join a lawsuit led by a lead plaintiff and get compensated. The class period for Tesla case is from August 7, 2018 to August 17, 2018 if you didn't buy or sell anything Tesla related and haven't already filed to join. As far as I know in research, you can only get compensated by the educational and perhaps entertainment value of the case. However, Tesla isn't the only shareholder lawsuits. Every year, there are about 74 shareholder settlement cases in the works, and the average value of the annual settlements is about $3.7 billion. Typically, retail investors like you and me represent 30% of the stock market, which means the shares of the US retail investors is about $1.1 billion in settlement compensations each year. You pay 20% to the lawyers, leaving the entire US retail market $900 million in compensations per year. How much you get depends on how much you invested and lost, but $900 million is no chump money and worth paying attention to. Where can you get more information in an easy to understand manner without spending hours researching these things on your own? If you know me or have used our platform as Stock Card, you know we are a fan of making the stock market digestible for all. So in a very Stock Card way, I plan to do more research and gather information on such cases and how you and I can be a part of them. If you want to receive additional information about future class action lawsuits, worth joining, or learn more about easy ways to join such cases, all you need to do is to become a Stock Card user. Mind you, that this idea is only in the research stage and I'm only gathering information, but I'll keep all Stock Card users in the know as I learn more and perhaps build features to help you do that. You can find ways to participate in future promising shareholder class action lawsuits by joining a Stock Card for now. So head to stockcard.io, sign up for a free account, and the bonus is that while you wait for me to gather more information, you can research your stocks and ETFs using our digestible insights platform at stockcard.io. The link is in the description too. By the way, the links to all sources used for this episode are also in the description, and you should check them out if you want more details. See you soon.